Okay, ladies and gentlemen, if I could please ask for everyone's attention, we're going to begin. We're running a little bit late, but I purposely wanted to give a chance for those who had some difficulties in getting here to find their way. So hopefully we will be joined by some others throughout the morning. First of all, can everyone hear okay regarding the sound? Yes? Excellent. All right, well, ladies and gentlemen, distinguished guests, Professor Figuera, it's wonderful to have the chance to be here today in Goldsmiths for the final day of the London Human Rights Conference. I think really it's been a fascinating few days where we've had a chance in an interdisciplinary as well as an international way to reflect on some of the challenges and opportunities facing not only the field of human rights, but also how it intersects, or maybe doesn't intersect, with cultural diplomacy. So today's the final day. The thematic focus is a little bit also looking ahead in terms of how we can also develop things in a positive direction. What steps and measures should be taken, what opportunities are there for us to actually address with our initiatives in cultural diplomacy or beyond. I'd like to first introduce our host for the day, Professor Carla Figuera. She is a multilingual researcher and university lecturer in international cultural relations, as well as strategic and operational manager of cultural public services. She's presently working as visiting tutor for ICCE at Goldsmiths College, as a researcher for international intelligence on culture, and as coordinator for the European Cultural Foundation of the UK Committee. In that capacity, I'm always grateful to her. She's very active in terms of also sending some of the most recent developments in terms of articles, developments, and she's really keeping me up to date in terms of the most updated developments in the field. Even yesterday I got some of the updates. But it's really great. So she's really on the cutting edge of some of the developments in the field of culture. So for that, I've also been grateful over the last few years. She's supported a briefing session also of the European Union staff on cultural diplomacy trends. From cultural diplomacy to cultural cooperation, ? That was in November of 2009. This research was revisited in 2011 and will soon be published and hopefully presented in Brussels next month. We were just discussing this morning. Carla has a PhD in cultural policy and management. Her education also includes an MA in arts management and a degree in international relations, with specialization in culture and political relations. She has worked as arts manager of the Department of Culture for the Municipality of Lisbon. So I'd ask you to please join me in a very, very warm welcome for our host today, Professor Carla Figuera. Thank you.
I just would like to welcome everyone, obviously the organizers, guest speakers and participants to Goldsmiths. It's very nice to have you all here. I'm a recent member of staff of ICE, which is the Institute for Cultural and Creative Entrepreneurship, one of the departments here. And ICE works mainly with postgraduate programs in social entrepreneurship, arts administration and cultural policy, and social entrepreneurship. Obviously the area I'm developing, cultural relations and diplomacy, falls within the arts administration and cultural policy program. And as Mark has mentioned, there's a series of events, research projects, meetings being developed in that area. Connecting with what you have been discussing over the last few days, human rights. In my research, although it was specific in terms of cultural diplomacy, I was interested in connecting it with cultural and linguistic human rights. Mark asked me if I could make a presentation on the subject, but unfortunately, I had other engagements and that was not possible this year. Hopefully, that will be possible in the future. So I don't want to delay you more, but I just wanted also you to know a little bit about, why you were at Goldsmiths. It's because we are interested in developing this area of cultural relations and cultural diplomacy. Some housekeeping rules, that's the only entrance and exit. You will find, also if you continue down the corridor, you will get to the green of the college, and around the green you will find different buildings. The building just opposite from this one is called the New Academic Building, and you will have on the ground floor also some cafeteria facilities. So at lunchtime, if you want to wander around, get a bit of fresh air, you will find the latest in our campus, which is that new building where ICE is on the 3rd floor. If in the future you wish to contact us, please do. My email is Europe, like the continent, at gold.ac.uk, and I'll be very pleased to get in touch, because obviously, as Mark mentioned, we run a group listing on Gmail that is also focused on international cultural relations, and hopefully we will, the group only started in March, but it gathers already participants from all continents. We are over 100 at the moment, and our aim is to exchange information on all aspects of international cultural relations, and hopefully as we get to know each other more and more, we'll be able to have projects together and contribute to each other's research and try to find our way through this difficult and new area that is still international cultural relations. So I just want to wish you a very good day of discussions. Thank you.
Thank you very much, Carla. So, ladies and gentlemen, they say actions speak louder than words, and our next keynote speaker for the morning, I think, is a great example of that. Someone who's dedicated not only the last 8 years, but actually beyond that, to really assisting when it comes to migration and immigration issues. Mr. Jerome Phelps has been working for 8 years with immigration detainees in Detention Action, which was formerly the London Detainee Support Group. He's currently the director of the Detention Action, a grassroots charity based in London, working particularly at Harmondsworth and Colnbrook immigration removal centers. He is the author of several articles, including, quote, The Lonely Death of Jimmy Mbenga, Fast Track to Despair, A Lifer is Better Than a Detendee, and No Release, Lives in Limbo. In his publications, Jerome Phelps criticizes increasing detention of migrants and defines the immigration detention system as expensive, inefficient, and inhumane mess. With a strong faith and commitment to humanitarian principles, he is fighting for the improvement of the immigration detainees' health. Ladies and gentlemen, please join me in a very, very warm welcome for Mr. Jerome Phelps. Thank you. You can either hold it or clip it in your...
All right. We'll endeavour not to drop it. That would be unfortunate. There we go.
It's for the PowerPoint.
Oh, wonderful. So... Oh, no.
We'll just switch to...
Fantastic. Thank you for the invitation to speak here. Just before I start, briefly to introduce my organisation, Detention Action, which I'm the director, as Mark said. So we're a small NGO working on the ground in detention centres, but both giving support and advice to people, migrants held in detention in prison-like conditions. And also we do a lot of work lobbying, campaigning for change to what is, in our view, a profoundly unjust system, as I will be explaining in a moment. So we are very active in Parliament and building networks amongst NGOs to campaign against particularly indefinite detention and other pressing human rights issues. We're very reliant on volunteers, particularly for our work visiting and supporting and doing casework for people in detention. So if any of you live in London and are around for the next few months and want to get involved in working with us, please speak to us afterwards. Now, if I can conquer the technology. Oh no, that was a mistake. Oh, here we go. Oh yes, there we go. Right. Alex. Eventually we'll get to yes. So there's a paradox, I think, of human rights and austerity in a time where governments are trying to save money. One might expect that economic social rights will suffer. The budget cuts in the UK that are going to could potentially force many thousands of people on housing benefit to move out of central London, for example, are going to have a huge impact on a range of rights. But one might expect that basic civil liberties would be less affected by austerity. Often breaching civil liberties can be a expensive business. In particular, immigration detention is a particularly expensive way of taking away somebody's rights, arguably. What we see, however, is that economic uncertainty directly leads to the sorts of anxieties, xenophobia that push governments into ever more ever more repressive and as well as expensive border control policies. There is this, from our point of view, the need to save money is a very powerful argument against immigration detention, but for politicians, the need to demonstrate toughness to anxious populations can outweigh that and is a potent political factor, and one that we struggle with, I think. So I think immigration detention, it works most effectively as a symbol of toughness on uncontrolled immigration. It's a symbolic gesture in the same way that Catgate erupted a few weeks ago. As those of you who live in Britain may know, Catgate refers to a speech by the Home Secretary, Theresa May, at the Conservative Party conference. Party conference being a particular moment where politicians tend to appeal to their core supporters within their party to bolster enthusiasm. Now, Theresa May described the need to crack down on foreign criminals taking advantage of the European Convention on Human Rights, protections of the right to a family life, Article 8 of the Convention. She presented an image of foreign criminals getting automatic rights to defeat deportation by invoking their family life. The case she cited was of someone who was given the right to stay in Britain because they owned a cat here. Needless to say, for anyone who has studied human rights discourse in the UK, it was simply not true. The person wasn't a foreign criminal. They were given the right. They were given the right to stay in Britain primarily because the UK's policy explicitly made it very clear that they did have the right to stay in Britain. They were in a long-term homosexual relationship. The ownership of a cat was a very incidental aspect of this very established family life. But it's the symbolism, it's the sense that we as a country are overwhelmed by these abusive foreigners who are taking advantage of our human rights laws to pull a fast one. And that's the context in which immigration detention functions and has increasingly functioned over the last few years. So I'm going to speak. Hopefully won't delay Don Flynn too long, who follows me, and it will be great value, I'm sure. But I'm going to speak for a few minutes to set out the evolution of immigration detention. How we've got to this point where we are now, I think, is crucial for understanding the interaction of immigration detention and human rights and the vast public spending that goes on it. So when we say immigration detention, what do we think of? What's the first things you think of when you hear the phrase immigration detention? Any ideas? Yes.
Imprisonment?
Imprisonment, yeah. They're very much, certainly in the UK, they are prisons. Yes.
Long time?
Yeah, people are held for very long periods, definitely.
Breaking up of families?
Yeah. It's there's been a lot of publicity around, particularly the detention of families, but also detention of members of families who are separated from everyone else.
I don't know if it's just me, but I associate detention with like school, with like discipline. Like after school, you know, you have detention if you like get into trouble. So it's a very degrading term.
Yeah, it's a really interesting association. Yeah, so it's this almost infantilizing, it's semi-punishment, but as though migrants are children who had to be held back from leaving. That's actually it's one I think we tend to forget, but it's actually quite an important resonance, and one that many UK BA staff I've spoken to, it comes out in some of the things they say. Yes, the UK has a growing immigration detention regime. It's large amounts of public money are spent, but what exactly are the purposes of it is the question. How have they changed over time? Are they proportionate to the interferences of essentially imprisoning migrants with the rights of migrants, and what's the implication of the financial outlay involved. If you in terms of human rights, unfortunately, one of the reasons that Fortress Europe has developed over the last decade or so, this growth of immigration detention, is the weakness of the human rights framework in Europe on immigration detention. The relevant article of the European Convention on Human Rights is informally known as the right to be detained. It gives almost no protection to migrants. It creates this pretty, in the text, pretty almost unlimited power to states to detain anyone that they view as making an unauthorised entry. And they can pretty much say, unauthorised entry, if I don't authorise you to enter, that means it's an unauthorised entry, so I can detain you. So it's almost a self-fulfilling prophecy. Very little protection in the European Convention. In a UK context, the power to detain go back to the Immigration Act 1971, which again sets out in very broad terms what the power of the state to hold migrants in immigration detention. There's various relevant paragraphs. This is one of them. Again, it's in very broad terms. Much of the detail that we grapple with day to day is in the policy guidance, but it's the 71 Act that we go to when you look at the legal framework. However, back in 1971, there was actually very little use of immigration detention. Detention had almost died out. It was used largely during and following the Second World War, where enemy aliens, primarily German nationals, were detained in relatively large numbers, and many were detained for several years after the war, pending deportation. But these centres closed around in the mid-50s, so very little happened in immigration detention until around the 80s or 90s. It's only really that in the late 90s that immigration detention begins to develop beyond this very minimal residual level. Traditionally, they've been detention places of detention have been facilities in airports, short-term holding centres with small numbers of places, and this assumption that it's for short periods for removal, which is not pursued with a great deal of political vigour in practice. The removal numbers are low as well as the detention numbers. So it's politically it's a low-profile issue. It doesn't really feature on the radar much, except in isolated cases, until the late 90s, where you see a Labour government coming in and inheriting an asylum system that is a bit of a mess. So from the late 90s, it's expanded from about tenfold. There was about 300 bed spaces then, and we now have 3,500. There's new centres have opened in Yarlswood for women, Colnbrook, new wings at Harmondsworth. There's been a great deal of political, financial investment in immigration detention in this relatively short historical period. It's gone from being nowhere to being a major political issue that Home Secretaries talk about at conference. That if you monitor the tabloids for any amount of time, it's a regular issue. The initial trigger for that is the perception of a crisis in the asylum system, the significantly increasing numbers in the late 90s that, by all accounts, left the system creaking. The Conservative government before '97 had not really paid any attention to asylum. It just wasn't an issue, and this led to very long backlogs, people waiting years for decisions, a system that wasn't really functioning effectively for anyone, for the rights of asylum seekers to have a decision in their case as much as for immigration control. So in '97, when the new Labour government came in, Labour are, as the left of centre party, are much more vulnerable to criticism traditionally on immigration. So it becomes an issue because the Conservative opposition makes it an issue, and Labour also, the Labour government also makes it an issue to demonstrate that they can be trusted to maintain strict border controls. So central to the Labour government's strategy for addressing the problems of the asylum system is the expansion of immigration detention, not just in terms of building more detention centres. It goes beyond that. What we see is a shift in the purposes that are invoked for detaining migrants. They're no longer just short-term facilities for getting somebody onto a plane. We start to see this mission creep into other purposes. The most dramatic being the opening of the creation of the detained fast-track asylum system, which was explicitly conceived and justified as a way of deterring bogus asylum claims that were a regular feature of the tabloid press in that period. The detained fast track is a system whereby a new asylum seeker is taken straight to detention, and the whole asylum process is conducted whilst they are detained to an accelerated timescale. It's changed over time. Initially they were detained just until their first decision and then released, but over the years has expanded to include the whole asylum system, which now takes in theory around a month. The refusal rate is 99%. So once you're on detained fast track, you are almost certainly going to be refused asylum. The government says this is fine. It's for straightforward cases. So the refusal rate shows how many bogus asylum claims there are. However, their means of identifying straightforward cases are educated guesswork is probably an overstatement. It's an immigration officer at the point of screening knows their country of origin, their route of arrival to the UK, their name, and they ask one question: why are you claiming asylum? That's all they know. On the basis of this minimal evidence, they route somebody into a detained process with a 99% refusal rate. So there's huge concerns about the right to asylum, the extent to which asylum seekers can get justice in their asylum claim. The majority they're given a duty legal aid solicitor, and the majority are dropped by that solicitor before their first appeal, so they have very little access to legal advice. It's an enormously problematic process. My organisation published a report this year called Fast Track to Despair, which is not an appreciation, which highlighted additional developing issues around the length of time that people spend sitting in detention before the process even starts, and the fact that the detained fast track has evolved from initially being in a low security reception centre, in inverted commas, to now it's many people are detained in the new wings at Harmondsworth, which are high security prison to all intents and purposes. They are built identically to a Category B prison. These are largely newly arrived asylum seekers with no criminal convictions, no security issues. So there's this creep not only of the initial purpose, but also of once detained fast track has been established, it sort of proliferates. It becomes more and more securitized. More and more people go through it. But we have to be clear, this is a qualitatively different purpose of detention. They are not being detained for removal. They're being detained for the administrative convenience of the UK border agency in considering their asylum claim quickly. It enables, the one thing you can say of the detained fast track is it's fast and it refuses people. And the UKBA still invoke that the danger of backlogs. They see the fast track as essential to keeping at least some claims going quickly and leading to very fast removals. That is a powerful incentive for them. So the detained fast track was started in 2000, and the in its present, more or less its present form, was started in 2003 in Harmsworth. So that was the first great expansion, proliferation of the purposes of detention. The second great expansion of detention in the last few years followed a second crisis, not unrelated to the initial crisis, inverted commas, of asylum numbers. This time it was the foreign ex-offenders. In May 2006, the then Home Secretary Charles Clarke woke up to a hurricane of tabloid headlines about the failures of the UK border agency to consider foreign ex-offenders for deportation. Essentially, as far as one can work out, they had about 3 staff working in a dusty office somewhere on identifying people finishing criminal sentences and pursuing them for deportation. So many, if not most, were simply being released and forgotten about, because it had never been an issue. These are largely, in many cases, people with leave to remain in the UK, but not British citizenship. So, again, under the 1971 Immigration Act, the UK has the power to revoke their leave to remain and detain them for deportation. This wasn't happening. It was a clear administrative failing, lack of investment, lack of attention. However, it became a major political scandal. Charles Clarke was reshuffled shortly afterwards, lost his job, and his political career never resurfaced. He lost his seat at the last election. At that point, there was already a perception of the UK border agency as failing, and that really cemented this reputation, particularly on the right-wing press, of the UK border agency, as it's known now, as not fit for purpose. This sense that they were failing to deliver their policies. So the response was, as tends to be the case when there is political controversy, rather than just address the problem, put right the administrative failures, there's this hysterical extension of the scope of people who are pursued for deportation. It's not enough to just address what you've done wrong. You have to go far beyond what you were originally intending to do. So they spent several years trying to deport Irish people and all sorts of crazinesses that got them nowhere. They lost large numbers of appeals in the courts. But what they did was, almost any foreign national finishing a criminal sentence of any length would be automatically detained. The High Court subsequently found that there was a blanket policy of automatic detention for many classes of foreign ex-offenders. This was a secret policy that conflicted with their published policy, and didn't give consideration to individual cases. So on both levels, it was an unlawful policy, and the case law is fascinating for anyone interested in the dysfunctions of contemporary government. So what this did, it dramatically changed the nature of the detention population. Suddenly you have large numbers of people finishing prison sentences and going into immigration detention, many of whom have lived in Britain since they're babies, didn't realise that they're not British, just because they'd never bothered to get a passport. Lots of, we support lots of typical guy being a Somali who came as a baby with their parents, lived in a deprived community, never went abroad on holiday, got into trouble, did a prison sentence. Suddenly they're told, you're not British, you're going to be detained. Now Somalia, deportations to Somalia have virtually never happened for many years. It being Mogadishu being the most dangerous city on the planet, it's not an easy place to deport people to. Does that stop the UK from routinely just sticking people in detention anyway? Of course not. It's a political priority to detain them. So you get this, suddenly immigration detention is no longer about getting people to the airport. It's about public protection is the phrase that's used. Getting people who risk reoffending and reopening this huge political controversy, just get them in detention, keep them there, and hope that something comes up. So what we've seen over the last 5 years is a dramatic increase in indefinite detention of people where there is little or no prospect of actually deporting them. Yet, because they're perceived because they're ex-offenders, there's a risk. The fact of having offended is considered a risk that you will reoffend. So it's very, very difficult to challenge your detention and get released. People routinely spend years just sitting in detention until the courts finally free them. And again, this is just as the fast track, this is a significantly new purpose of immigration detention. They're not being removed. The border agency probably know that their chances of removing any of the Somalis currently in detention are slim to zero. But it's actually in the court judgment I referred to. They disclosed some hilarious email disturbing hilarious email conversations around civil servants saying, we can't deport this person, but we're detaining them anyway. This could be a bit unlawful, couldn't it? Yes, but let's leave the courts to release them, and then they can take the flak for it. So there's this sense of civil servants just not wanting to take responsibility for the inevitable release of these people. My organisation published a report on this as well in our former name, with 2 reports in fact, where has a large focus on the testimony of the guys who are locked up in high security centres for periods of years, and what it feels like to just have indefinitely lost your freedom. People saying things like, many of the people we interviewed said, I'm doing a life sentence, that's how I deal with it. I just tell myself that this is my life forever now, and I just have to get used to it. From a human rights point of view, it is a really dramatic, very serious issue that has had very little attention compared to the debate over 42 days detention for terror suspects, for example. And interestingly, another very unpopular group, a detention for a much shorter period, which was not actually yet happening, but was just proposed, became this huge political debate and was considered unacceptable. Yet the guys we support, trivial offenders often, are detained for many times longer than their prison sentence, ultimately for no real purpose. So I'm getting behind on my PowerPoint. And this is really a very exceptional practice. The rest of Europe has, with a couple of exceptions, signed up to the European Union Returns Directive, which has been rightly widely criticised for having a time limit of 18 months on detention. So in the rest of Europe it's seen as a terrible thing. In Britain we sigh and think how wonderful it would be if people could only be detained for 18 months, which is a very bizarre contradiction between the UK and Europe. The human rights impact, as I said, going back to the start, European Convention on Human Rights ain't much help here. It's the threshold for a human rights breach is very high. And breaches of there were attempts to challenge the lawfulness of the detained fast track against Article 5 that I cited earlier, Article 5(1)(f), which failed because the European Court found that the government had essentially a right, a limited right, by the way, but a right to detain asylum seekers to prevent them making an unauthorised entry. Likewise, Article 5 has been no use to long-term detainees. However, the scale and the problematic nature of long-term detention of foreign ex-offenders has just this summer, actually, it started to be considered to reach the threshold of Article 3, which is torture, inhumane and degrading treatment. Very high threshold for a civilised country running an immigration detention regime. UK has breached it twice in the last year, with in both cases S and BA, both massively vulnerable mentally disordered people. One was a rape and sexual violence survivor. The UK, in both cases, ignored abundant evidence, including from their own healthcare contractors, that these guys were, both of whom we were supporting, were not fit to be detained. And they were both detained for around 6 months, in which time their mental health collapsed. BA almost died, and he was refusing food, and they were working out an end-of-life plan for him, and the UKBA was still maintaining his detention, which was a bizarre situation. That the High Court found in both cases that this breached Article 3. So the UK Border Agency has a real problem now around how to manage its detention of particularly mentally disordered people. Long-term detention of people without these very extreme mental health issues. There has been a growing body of case law around it, not primarily on human rights grounds, to Theresa May's great disappointment, I'm sure. But there's been a series of unlawful detention rulings that invoke the 1971 Act and the case law that's developed out of that, that have found that because there's no prospect of removal, the detention is unlawful. Another of our clients, Amin Sino, was detained for 4 years and 11 months. He is a petty thief, and he had a few minor offences. The High Court found that the whole of his detention was unlawful, because there was never any. The UKBA should have known perfectly well on day one that there was no prospect of deporting him, but they held him for 4 years and 11 months. We've had several Somali cases of people detained for years who've also succeeded in the High Court. So there is a real there's momentum, I think, that's forcing the UK to address this dysfunctional policy. So if long-term detention is, in particular, is massively problematic from a human rights perspective, how does it measure up in terms of efficiency, coming back to our theme of austerity? So you can see not huge numbers, but significant numbers of people very long-term detained, 217 at the last official statistics. Detention is not cheap, £130 per person per year, or £47,000 per year. That's taxpayers' money that's going to private security companies. And look at the statistics. If you're investing so much money in detaining somebody that you really, really want to deport, that you're prepared to keep them for a year or more, you'd expect to be getting really high deportation outcomes if you're want it that bad. In fact, 57% are released. The longer you detain somebody, the longer they're detained, the less likely they are to actually be deported. And we did some calculations that the increasing size of the detention centre has actually, they've increased the detention centre by estate by half since 2007, yet the numbers of removals have actually gone down. It's a massively inefficient system. So, to conclude, is detention proportionate and efficient to human rights and austerity? Clearly, from our point of view, it isn't at all. It's what I've tried to show is this incremental, lurching extension of the detention policy that follows no coherent plan. It's almost a defensive, reactive policy that each time there's a new political crisis and a need for more symbolic toughness, detention is the knee-jerk response of choice. Successive governments wheel out increased use of detention for a new purpose as a solution to the perception that we're not in control of our borders. It doesn't add up to any kind of coherent policy. The UK approach is inconsistent with similar countries on the continent. Different nations have followed very different trajectories. And there's abundant evidence internationally from places like Sweden, Australia, Belgium that actually, if the UK is honest in its claimed objectives of maintaining immigration control, ensuring the return of people that are found to have no right to stay, the best way to do it, in every point of view, from rights and efficiency point of view, is case management based alternative detention systems, whereby people are given support, advice, legal advice throughout the process. You move away from this sort of adversarial system where you're fighting to stay, to enabling migrants to make reasoned decisions about their future. And in fact, in many of these systems, large numbers of people choose voluntary return when they're refused. It's far more effective to work with people and let them make decisions than to just beat them over the head with detention. But what detention does is symbolically reassure a lot of very frightened, anxious voters in the UK, and that's its primary purpose, I think, which is a very unfortunate state of affairs. So to conclude, my thesis is that there really is a direct connection between Catgate, this entirely absurd, concocted controversy, and the reality of Colnbrook, which is one of the centres where we work. It's the highest security centre in Britain. It's where most of the long-term detained people are held, routinely for years. We watch people held there going quietly out of their minds over very, very long periods. That is the reality that is created by this empty posturing symbolism of immigration control. Thank you.
You take one or two questions? Or?
Oh yes, I can take questions now or in the debate, or however.
You can just take one or two direct questions now, and then we do have a panel discussion later today. Please, the newcomers can take your seats. We'll start maybe in the front.
I'm curious about victims of human trafficking. I'm assuming that they're also in these detention centers, and if you could talk a little bit about them.
Could we group maybe?
Yes, yeah. Should we take two or three? Yes.
The ambassadors here as well as our next speaker. So
yeah.
we have Mr. Smith.
Hi, my name is Jessica Walker. I'm soon to be human rights lawyer from Australia. I'm just going to ask you if, perhaps at the start of your response, would you define your terms a little more clearly? Because as I understand it, there are two very distinctly different concepts that you're dealing with here. There is the question of an asylum seeker who who has someone who, under an international convention, has entered a country and said, I am a refugee, but has not yet been proved to be a refugee. So that's what we refer to as an asylum seeker. And then there is an illegal immigrant, who is someone who has come to the country for immigration purposes without having a legal right to do so, or who has lost the legal right to do so. Can you just clarify a little bit for me what your terms?
Sure. And maybe can you one or two more? Is that okay?
A couple more. Yeah, I might start writing these down before.
Two more.
I've studied similar issues in the States, and I wonder if there's any responsibility for lawyers to inform their clients what the immigration implications will be. If they, for instance, plead guilty to something that would then result in them being detained pending deportation, as opposed to if they fight it. I just know that that's a big issue, and whether they have a right to be informed what the immigration implications may be.
Yeah.
It does remind me a bit about Guantanamo. Does Amnesty have an opinion on this?
To start with, clarifying the terms as the initial question. You're right. I didn't go into the types of people can be detained. Partly because I would dispute there's a simple dualistic typology like that. There are different types of people, but many of the categories overlap. The main ones are people who have claimed asylum, who have either been refused or judged straightforward, and foreign ex-offenders pending deportation, visa overstayers, student visa breaches, illegal entrants. In law, there's no category of illegal immigrant.
Is Britain a signatory to the Refugee Convention?
Yes.
Does that not then create very distinctly different categories as to what the remedies are and what you can contend Britain might actually be breaching its obligations under? Clearly there are differences between asylum seekers and non-asylum seekers, certainly. In my experience, most of the foreign ex-offenders, the majority claim asylum. It's very difficult to separate clearly asylum seekers, refugees on one hand, and illegal immigrants, non-asylum seekers on the other. Partly because there are so few remedies outside the asylum system that a lot of people get funneled into the asylum system almost against their will, because that's the only way they can access any kind of legal process. And people have overlapping situations. Many people have claimed asylum, been refused, gone to prison, been recommended for deportation, make a fresh asylum claim, make an Article 8 claim. There are lots of overlapping categories. And yes, absolutely, the Refugee Convention brings a certain structure. But in detention, it's largely people who are found or will be found not to require protection under the Convention. So once we're talking about refused asylum seekers, then in practice it doesn't make a great deal of difference whether you're a refused asylum seeker or a student visa breacher. The major difference is, not wanting to get too detailed into the law, between the ex-offenders with a deportation order and non-offenders who are facing administrative removal. There are some technical differences there, although increasingly it doesn't make a lot of difference. The main difference is it's much harder to get out if you're a serious offender, and that's almost not a legal distinction. It's graded and based on perceptions of judges and the DBA. Trafficking, not an area I'm very expert on. Don might have more background on that than me, I'm not sure. Certainly there are issues around, particularly in Yarl's Wood, with the detention of women, where there are some regulations in place to give people who have been trafficked breathing space before they return. It's a very short breathing space, and they can and are detained at the end of it. So it's a fascinating issue, the conflicting duties to protect victims of trafficking and support them in prosecutions, against the border control objectives of returning them, and I think the UK is very far from solving that question. Yes, it's lawyers informing, criminal lawyers informing migrant clients of the immigration impact of a criminal conviction. It's a big issue here as well. Most migrants accused of a crime will often they will get a local criminal solicitor who will typically know very little about immigration law. So it's the biggest issue tends to be asylum seekers accused of using a false document, who often either to work or particularly when they first arrive in the country. There is protection under the Convention of the right to use a false document to claim asylum, but criminal lawyers are often not aware of this and advise people to plead guilty. And more broadly, people, when they claim guilty to minor criminal offences, they often have no idea that it could lead not just to a short period in prison, but to losing their leave to remain and potentially a much longer period in detention. So it's certainly an issue. And Guantanamo, yes, it's interesting parallels. Again, this is a big topic. I think there is involvement of Amnesty. Amnesty has worked on immigration detention in the past, not so much recently. It is an ongoing and very interesting question, the intersection of detention, migration and human rights sectors in the NGO field. Generally, we've been very separate, and to generalise, a lot of human rights organisations have tended to leave immigration issues to the immigration specialists, greatly to the detriment of the immigration human rights issues, I think. So there is a sense that migration NGOs and human rights NGOs should be working together more effectively and seeing the overlap between these issues. So I think seeing these massive human rights abuses of migrants as what they are, fundamentally human rights abuses, the fact that they target migrants should be incidental. I think we need to move beyond this idea that there's one set of rights for the citizens and then there's another very, very much more limited set of rights for non-citizens. And I hand over to Don now.
All right, well, first of all, if we please express our gratitude to Jerome Phelps.